You've heard these melodies 1,000 times, from the puzzle-clearing panic of the Tetris theme to the blistering chromatic runs of Flight of the Bumblebee. But if you attempt to license them for a film or a game today, you'll encounter a landscape of shifting borders and conflicting treaties. Ownership of Russian and Soviet music is governed by an overlapping timeline. To find a single-song status, you have to account for dismantled empires, 1920s socialist mandates, and modern laws that retroactively pulled old works back into protection. To manage this, archivists look to a musicological framework called the Chopin order. It is a system for organizing works with absolute chronological precision, sorting music by the exact moment of creation rather than the date it reached a printing press. By mapping this catalog era by era, we can identify exactly where the legal cutoffs fall and which portions of this history are actually free for the world to use. This map begins with the folk bedrock era, spanning centuries before the 1700s. This is the origin of traditional melodies like kalinka and korebeniki. Under Article 1259 of the Russian Civil Code, these melodies bypass copyright logic entirely. Because they evolved through oral tradition without a single identifiable author, they are classified as folklore, meaning they are legally free to use globally forever. Moving into the 19th century imperial era, we encounter the massive orchestral works of Tchaikovsky, Mussorgsky, and Rimsky-Korsakov. Verifying the original, unencumbered arrangements of these works require historical sheet music. Archivists use documents like this 19th century Danse Russe score to ensure the music they are preserving follows the composer's original public domain intent. The standard copyright term in the European Union is the life of the author plus 70 years. Because these imperial-era composers died over a century ago, their entire catalogs easily clear that hurdle. For these first two eras, the combination of ancient anonymity and the sheer passage of time creates a permanent barrier against modern copyright claims. The math changes after the 1917 revolution. This period saw a surge of radical industrial music from the Soviet avant-garde, led by composers like Mosolov, Prokofiev, and Shostakovich. In the European Union, much of this music remains locked. Because many of these composers lived past 1955, their works are still protected under that life plus 70 rule. This diagram shows the divergence between EU and US copyright filters. The top half shows how the EU blocks access based on when a composer died. But the bottom half shows the US system, which allows works through based on a hard publication cutoff. In the United States, any work published in 1930 or earlier is definitively in the public domain. This creates a specific gap.
While the EU maintains a wall of protection for these composers, the US side acts as an open gate for anything they published before 1931. This results in a split legacy for creators like Dmitri Shostakovich. While his later symphonies are strictly protected, his earliest, most radical works from the 1920s are legally cleared for use in the US. For digital archivists in the United States, this publication cutoff creates a golden window for preserving the modernists of the early Soviet era. As the timeline moves past 1930, we enter the era of Soviet mass songs and official state anthems. Most Soviet works published after 1930 were pulled back under U.S. copyright protection by international treaties, a move the U.S. Supreme Court ultimately upheld. This ended the period of free accessibility for nearly all mid-century compositions. There is, however, a final exception. Official state symbols and anthems are inherently immune to copyright under Russian law. This renders the instrumental arrangements of these anthems completely free to sequence and distribute. In a strange twist of legal history, the music explicitly commissioned by the state is the only portion of the mid-20th century catalog that is functionally free for global use today. We have successfully cleared a massive chronological catalog of compositions, but if you upload a modern orchestra's recording of these pieces to YouTube, it will still trigger an automated copyright claim on the specific audio recording. To navigate this, archivists use the Musical Instrument Digital Interface, or MIDI. The difference between an audio waveform and a MIDI file is clear. A recording stores the physical vibration of sound. MIDI stores no audio at all. It functions as a grid of performance instructions.
containing only data for velocity, pitch, and note duration. By using Format 1 files, archivists can isolate every individual instrument in a complex symphony. They can recreate a Rimsky-Korsakov masterpiece, note by note, without ever relying on a protected sound wave. By pairing the chronological rigor of the Chopin method with the data-driven architecture of MIDI, archivists have built a path through a century of jurisdictional gaps. They've successfully cleared a repertoire that, until now, seemed legally impossible